So for no mama kwa buy the Punch TV so me so say any day di kind na dey her channel ya. Obe subscribe dey am no like no share. We so jaw adwenche or comment section ho so e dey akan ho. So I subscribe so that I beka say Nyankopon on show. On try wa shim. Ebusuan for family ameka say a story be na theater for mama nkofo twene ni abasa. Social media no so dey okọ ho a chese. Baby abefa bia enam ho. And I say the Punch TV so dey emfa nkame ya hwefo. Inti yeso akọfa story na yeso ye dey abra ya hwefo say omonje no munti no so nhwe bi. No munti nsema yakoso. Ewo ye Ghana we. Abusuan for my enko ni nkoti Asem no emra ye ba ye de mu nchemu nyina esa ebebrem.
Thank you. Can I get you? Yes.
Arrogance. I disagree.
Hold on. Let's all have one person speaking. It's fine. Let's all have one person. Thank you. Can I? Let's have some discipline.
Can I have?
Yes.
But they are talking.
I wouldn't do any law.
For example, yes. Thank you.
There are two issues that there are two issues. Excuse me. There are two issues that I want us to have clarity on. One, the application to the court and the reliefs sought by Richard Sky are captured here, and there are two. An order of interlocutory injunction to restrain the Speaker and the Clerk to Parliament of Ghana from presenting to the President for his assent through the Attorney General from assenting to the Human Sexual Rights and Family Values Bill passed by the Parliament of Ghana on 28th February 2024, pending the final determination of the suit. So he's seeking to restrain Parliament from presenting the bill. Yes. But that's a relief aimed at the Speaker, not the President. Okay? Then the second one is to the President. An order directed at the President from giving his assent to the Human Sexual Rights and Family Values Bill 2024, passed by the Parliament of Ghana. So he's seeking to restrain Parliament from presenting the bill to the President. Then he's seeking to restrain the President from assenting to the bill. He has not sought any order to restrain the President from receiving the bill. He has not.
Oh, but you just read
No. That order is aimed at the Speaker. Read it carefully. It says, an order of interlocutory injunction to restrain the Speaker. And the Clerk of Parliament from presenting to the President. If they choose to go ahead and present it to the President, that becomes their legal problem. The President is not restrained by the reliefs being sought by Richard Sky from receiving. Do you get it? Now, the Secretary to the President writes his cease and desist letter. And he says this, and let's read it carefully. He says that the Attorney General has, by letter dated 18th March 2024, informed the President that he has been duly served with both applications and has advised the President not to take any steps in relation to the bill until the matters raised by the suits are determined by the Supreme Court. It is the understanding of this office that both applications have been duly served on Parliament. Therefore, it would be improper for you to transmit the bill to the President, and equally improper for this office to receive the bill. That's where he's wrong. It may be improper for the Parliament, pending the issues of the application, to transmit it, but that's a matter for them to decide whether they want to be in contempt. But it is not improper for the President to receive it, because nobody has sought an order to restrain him from receiving it. The only order that has been sought is to restrain him from giving his assent. But because, in my opinion, my candid opinion, the whole writ was contrived to give the President a cover not to receive it, even though there's no order in relation to him not receiving it, he just jumped at the writ and said, hey, I don't want to receive it. because there's a matter in the court. So clearly, it is wrong. But that is even not for me the only issue. There is an even more. Listen. There is an even more fundamental issue. Let me finish.
Gentlemen.
Please.
Thank you.
There's an even more fundamental issue here, which has not, in my opinion, in all the discussions that I've heard, been canvassed. Therefore, let me continue the quotation. Therefore, it will be improper for you to transmit the bill to the president, and equally improper for this office to receive the bill until the Supreme Court determines the matters raised in the suits. Indeed, it is settled law that during the pendency of an interlocutory injunction application, the status quo ante ought to be preserved, and no action should be taken that will result in prejudicing the injunctive relief sought and determining the authority and undermining the authority of the court. In the circumstances, you are kindly requested to cease and desist from transmitting the bill to the president until the matters before the Supreme Court are resolved. This is equally palpably wrong. Do you know why? The same Supreme Court, in the interlocutory application by Amanda Odoi, Amanda Odoi, in her interlocutory application to the court said this, and pay attention. The court said, we have considered the merits of this application before us. It is our considered opinion that a prima facie case has not been made to convince us to restrain the work, listen carefully, to restrain the work of Parliament in its uncompleted form. To restrain the work of Parliament in its uncompleted form. Uncompleted form of what? The passage of legislation. So the Attorney General ought to have advised himself as to what is the completed form of legislation. The completed form of legislation is when it is initiated in Parliament, goes through first, second, third reading, after consideration, gets voted by parliamentarians, is transmitted to the president considers it, either assents to it or refuses to assent to it, sends it to Council of State for advice, takes the advice of the Council of State and the opinion of the president and his recommendation, sends it back to Parliament. Parliament considers or reconsiders its provisions in addition to the views of the president and the Council of States, and either passes it by 2/3 majority or not. That is the completed form of the passage of legislation. So the Supreme Court has already indicated that in the entire process of the passage of legislation, we will not interfere. So it is wrong for the Attorney General to have been said to have advised the president that he should not assent to the bill. When the court has already said that, we don't want to even interfere.
Yeah.
So even if somebody has brought an application to us, we don't want to interfere, go ahead, go through the entire process. So the entire process includes the president saying that I disagree with you, I'm sending it back to you, go through reconsideration, mobilize your 2/3. If you succeed in passing it, you bring it and I assent. That is the entire form. And the Supreme Court has already pronounced on that matter. So it is wrong for the Attorney General to ever advise the president that he should not go through the processes. One, either say, I disagree with you and send it back, or two, say, I'm signing, because when he signed, it is still part of the process. So he hasn't violated any rule. He hasn't undermined the judiciary. He hasn't violated the decision in Amanda Odoi. And in fact, he has complied with it when he goes ahead to either assent or refuse and communicate it back. So the Attorney General was wrong. In fact, I am shocked and scandalized by the advice of the Attorney General in this instance. That's what I want to highlight this morning in this discussion. So I disagree with what has happened. The second issue that I think we need to understand is that I have an issue with the Supreme Court ruling in this interlocutory application of the Fiamapo. I may have some reservations about the righteousness or not of the letter that has been written, okay? But what is the substance of the Fiamapo's case? The Federal Court is relying on Article 81 of the Constitution. What does 81 say? It says that the office of a Minister of State or a Deputy Minister of State shall become vacant if his appointment is revoked by the President. The President writes to Parliament, lists people and says, I have revoked these people's appointments. First,
can I caution you?
First,
you are almost determining the matter.
No, we can discuss it. No, we can discuss it. No, we can discuss it.
Let me even state that we are mindful of the subjudicate, and so we are mindful of our timelines and then also the boundaries in the conversation of this case. So yes, we are not really determining the case on this platform, but we are discussing it within the boundaries that we are allowed to.
We can discuss the facts.
Yes,
the facts are public record.
Yes, indeed.
The communication was read to me.
Yes, that's that. I just needed to state that.
The communication first said that these appointments have been revoked. Then after saying these appointments have been revoked, then below, so I have reassigned them to X, Y, Z. Then the Federal Court said, but you've already revoked the appointments. So if you have revoked the appointments under Article 81, where are they to be reassigned? This is the case.
Go through the process.
Yes, this is the case before the Supreme Court. Now the Supreme Court says that, don't worry, you go ahead and do whatever you have to. I won't grant an application for interim injunction. That is so. I don't think that we should relate the substance and nature of the Federal case in relation to Richard Sky's case. Because in Richard Sky's case, so far as I'm concerned, in the Amanda Odai rejection of interlocutory application, the court has already ruled that whoever is a participant in the entire process of the lawmaking should continue with their responsibilities and not be restrained, including the president. So for the Attorney General to advise him against giving his assent and not advise him to take the steps dictated in the form is woefully wrong, and I feel scandalized by it. Then on this, you see, I take a position personally that there's no specific rule that says that when you write to the Chief Justice,
notify
to seek an early hearing of a matter, that you must necessarily copy. But I have said here that it is only proper for you to copy
on the platform of fairness.
Yes, on the platform of fairness and also just administrative prudence. I also agree that when the Chief Justice is responding to you, because there's a third party involved, is that okay? That the Chief Justice notifies the third party, copies the third party, so the third party is aware. I heard somebody said, and I think I 100% agree with that administrative.
That's what Biban said.
Yes, his position, and I think that it was administratively, not the best that the Chief Justice did not copy, the other party when responding to the lawyers applying for an early hearing. But the reason why the Chief Justice ought to inform the other party is that if you read the notice to let's say the former court lawyers, what does it say? It says that, let me read it. That is fixing of date for hearing of application generally. It says, please take notice that a date will be fixed for hearing of the above stated application with hearing notices for the respondents by the registrar upon request, 14 days after service of the application on the respondent. 14 days.
14 days.
So when you send an applicant this notice, that applicant legitimately will expect that he has 14 days. Okay? After the service on the respondent. So there is a legitimate expectation that I have this time frame within which to work. if you then decide to go ahead and then have the hearing much earlier, I think that administrative prudence will require that they be given adequate notice. And I heard the lawyers indicate that they have issues with the service, and they actually indicate that the bailiff lied to the court. Bailiff lied to the court. So I believe that in a matter like this, given the political nature of this case, the Chief Justice should cause an investigation of the conduct of the bailiff.
At least on the face of the CCTV video we have just shown.
So that we are all clear as to exactly what happened. Because like Prof has said, this is a matter that deals with the reputation of the judiciary. Already, NDC has issued a statement questioning why this matter came before this other matter, and yet you are choosing to hear the one that came, after the first one. So it is important for the image of the judiciary for them to be interested in whether or not, because I heard the lawyers on radio say that the bailiff lied and that they have CCTV cameras. And they've shared the CCTV cameras. You've shown it. I watched it. You've shown it. So, in the light of this, I believe that the Judicial Secretary and the Chief Justice should be interested in investigating the conduct of the bailiff to see whether he misled them into refusing to give an opportunity to the applicants to be heard. Because it's a rule of natural justice that the party should be heard. And that is why I decided to go to the substance of the Kwemofos case. Because I believe that if they had heard him, they would have seen that first, Parliament is on recess anyway. Are you getting the situation? And secondly, really, he's not really talking about the process in Parliament, essentially. He's talking about the conduct of the president, even before coming to Parliament. First announcing revocation, and then purporting to announce reassignment. So it's not the same thing. It's not a process in Parliament. Okay? It's the conduct of the president outside Parliament. So I think that there's something to distinguish in relation to the two matters that are before the Supreme Court. And even though it is all in the context of a political tussle between the legislature and the executive, but in truth also, there is a legal issue when it comes to the Court case. And there has never been a precedent like that. And we're all interested in what the Supreme Court will say in that matter.
Let's see how things play out. And you talk about the tussle between the judiciary and the legislature